Welcome, and thank you for standing by. At this time, all participants are in a listen-only mode until the question and answer session of today's call. At that time, you may press star then one on your touchtone phone to ask a question. I would like to inform all parties that today's conference is being recorded. If you have any objections, you may disconnect at this time. I would now like to turn the conference over to Diane Potts. Thank you. You may begin.
Thanks. Welcome, everyone. My name's Diane Potts, and I work with the Division of Policy and Training at the Office of Child Support Enforcement. On behalf of Commissioner Scott Weekend and OCSE, I'd like to welcome all of you to the fourth webinar in this six-part training series on Interstate Case Processing, Interstate Payment Processing. OCSE has had a very positive response about these trainings, and OCSE is so pleased that you're finding them useful. From the evaluations from the last training, Interstate Scenarios, OCSE heard that all of you really enjoyed the interactive polling format. So we're working to integrate this interactive format into future webinars, including the training today. OCSE also heard that you want opportunities to ask questions, and we'll do our best to address questions today. But if we don't get to your question, we encourage you to please send in that question to OCSE by email after the webinar, and the email address will be listed at one of the last slides on the presentation. Also, last week, OCSE emailed a technical assistance document that included over 40 Q&As from the webinar series. The document went out to all registrants from earlier webinars. OCSE hopes that you find this technical assistance document useful. And after the Interstate Training Series is complete in February, OCSE anticipates consolidating Q&As from each of the webinars and issuing an official OCSE policy document addressing these questions. I want to thank everyone who participated in OCSE's Interstate Training Series, including Interstate 101 and 201 and Interstate Scenarios, and give a special thanks to those that responded to the post-webinar evaluations. Today, we have almost 800 registrants to learn about a very complex topic, interstate payment processing. So without further ado, welcome to the training today. Today, we're going to look closely at Action Transmittal 1707, which was published by the Federal Office of Child Support Enforcement and provides states guidance on interstate payment processing. Because interstate payment processing can be a bit confusing, this training includes scenarios that apply interstate payment processing principles to actual case facts. The scenarios are designed as tools to illustrate different case processing choices, and there may be more than one case processing choice available to a state based on the same scenario. For many of the scenarios, you'll have the opportunity to consider the most appropriate answer given the facts of the case. And we'll have live polling during this training where you'll be asked to respond after each polling question. Possible responses will appear on the right side of your screen. If you're viewing the slides in full screen mode, you may want to exit that full screen mode so you can view the poll and the scenario. Select your response by clicking on the button next to the answer that you believe is the most appropriate, and then click Submit. If you're listening as a group, provide the most popular answer in your group. And after the responses are received, we'll discuss each polling question. We'll be able to see how many people selected each response, but be assured your responses are anonymous. And we'll also have a question and answer section in the middle of this training and at the end. Also, as in the past trainings, you can type your question in the Q&A box on WebEx anytime. So these on the screen are the 6 training modules in the series. We've completed Interstate 101, Interstate 201, and Interstate Scenarios. These trainings can be found on the OCSE website. Future trainings in the Interstate Case Processing series include Interstate Case Closure, Interstate Tools and Resources. And all of these trainings focus on interstate cases and are really intended to complement rather than repeat OCSC's training on the revised intergovernmental forms and international case processing. Please note that in some instances, UFSA does provide different rules for international cases. So let's go ahead and begin. On July 17, 2017, OCSC issued Action Transmittal 1707, which provides an in-depth examination of interstate payment processing. It includes available case processing options and explains how those options affect the flow of payments through state disbursement units. It also clearly delineates record-keeping duties in 40 cases and state disbursement unit payment records for non-40 orders. In addition, AT 1707 includes guidance and best practices on the use of redirection of payments under Section 319 of UFSA, which was one area in particular that states were struggling with after UFSA 2008 was adopted by all states. We'll talk in more detail later in the training about UFSA Section 319 redirection, which the AT defines as the change to the payment location set forth in the child support order by the order issuing state. AT 1707 also has scenarios and diagrams to illustrate the payment flow for each case processing option. OCSC hopes everyone has read the AT or will read it after today. While it doesn't cover every situation or every issue that arises in interstate cases, and it doesn't consider cases between State 40 agency and tribal programs or State 40 agencies and foreign countries, it's a good foundation upon which to guide child support professionals and then later build on with greater complexities and additional issues. And now I'll turn it over to my co-presenter, Jeanette Savoy.
Good morning, everyone. So one important principle throughout the AT is that the state providing services to the custodial parent has the responsibility to determine the most appropriate service to provide in that case. The 40 agency needs to look at all of the facts, including whether and how other states are involved with the case and whether payments are flowing. There are a number of interstate communication tools that can help caseworkers determine these facts in deciding the best option for that case. These tools are the Child Support Enforcement Network, or CISNET, and the Child Support Portal applications, the Federal Case Registry, or FCR Query, Query Interstate Cases for Kids, or QUIC, and the Electronic Document Exchange, or EDE. OCSC's upcoming Interstate Tools and Resources training will explain how each of these interstate communication tools work. Today we're going to talk about 5 case processing options that states may consider when working interstate cases, and they include payment forwarding, one-state remedies, the traditional 2-state cases under UFSA, intrastate enforcement of another state's order, and UFSA Section 319 redirection. Before we get started, OCSC understands that every state system has different limitations, and OCSC has heard from several states that one or more of these options may be difficult to achieve given those limitations. But OCSC has also heard from states that are working through system limitations so that all of these options are available to provide families with the most appropriate service for these sometimes difficult cases. States must make sure that their processes, whether system-generated or manual, are able to accommodate all 5 case processing options. For UFSA Section 319 redirection, however, it's important to note from the outset that a state is never required to make a redirection request. However, if a request is made and the criteria under UFSA are satisfied, states must comply and process that request. And now I'll turn you back over to Diane.
Thanks, Jeanette. So let's get started with payment forwarding. States historically have referred to the concept of payment forwarding as redirection, which has added to the confusion because USDA uses the term redirection to mean a different process. OCSE is urging everyone to use these terms consistently according to the AT and to restrict the use of redirection to the process contemplated under USDA. So payment forwarding is when the State Disbursement Unit, or SDU, in one state sends child support payments to another state's SDU. This movement of payments between SDUs occurs most often in the traditional two-state case, but it also can happen upon request of the state providing services to the custodial parent without referring a two-state case. In the AT, OCSE defines payment forwarding as, quote, the disbursement of support payments from the SDU in one state to the SDU in another state, regardless of whether there is an interstate 40 case between the two states, end quote. The capacity of state systems to forward payments between SDUs is a requirement of federal law. Therefore, if a state receives a payment forwarding request, it must comply with that request and forward payments it receives through its SDU to the requesting state's SDU. In a traditional two-state case, payment forwarding is routine and automated. The responding state's SDU will automatically forward payments to the initiating state's SDU. Payment forwarding in the absence of a two-state case, however, is something a state must specifically request from the state receiving payments in the case. So to request payment forwarding when there is not an open 4D intergovernmental case, you should use the revised Child Support Enforcement Transmittal Number 3, Request for Assistance Discovery. This slide shows the box to check to make the request. A state can use this form to send another state a request for payment forwarding without initiating a two-state case. The assisting state does not open a 4D case. Instead, the assisting 4D agency notifies its SDU that payment should be forwarded to the requesting state's SDU instead of to the custodial parent or a different state's SDU. States are going to find payment forwarding a good option in cases where there is an income withholding order collecting support in the state that issued the order, and the custodial parent applies for services in a new state. Because it now has a 4D case, the new state has a responsibility to monitor compliance with the support order. And it can do that by sending a Child Support Enforcement Transmittal Number 3, Request for Assistance Discovery, to the order state and requesting payment forwarding. The federal financial participation, or we call it FFP match, is available to facilitate payment forwarding requests, and both states may count collections received through their SDUs for incentive purposes.
Now, let's look at a specific case to illustrate how payment forwarding works and when it's the most appropriate service for a family. We are using real state names in the scenarios to help with our discussion, but they're randomly chosen and do not reflect what a particular state may actually do. In this scenario, a tribunal in Texas entered an order for Carl to pay child support to Anna for their son, Ben. Anna and Ben moved to New Mexico, and Anna applies for TANF. Carl remains in Texas. The 4D agency in New Mexico investigates and learns that Texas does not have an open 4D case, but there is an income withholding order collecting support from Carl's employer in Texas. What should the child support professional in New Mexico do? First, because Anna has applied for TANF, New Mexico must open a 4D case and decide the most appropriate service for the family. Since there is an income withholding order in effect that is collecting and dispersing support through the Texas SDU, The most appropriate service may be for New Mexico to send the Child Support Enforcement Transmittal Number 3 to Texas requesting payment forwarding. Texas must comply with that request. Once it does, payments will flow from Carl's employer to the SDU in Texas, to the SDU in New Mexico, and the pass-through, if applicable, then would go to the family. Remember that payment forwarding is just one option available to states. We'll look at one-state remedies next and then discuss referral of a two-state case. But first, let's have a polling question.
So just as in our interstate scenarios training, this is a polling question where you'll be able to select the answer you believe is the most appropriate. So we're going to use the facts in scenario 1. New Mexico decides to send the Child Support Enforcement Transmittal Number 3 to Texas, requesting payment forwarding from Texas's SDU to New Mexico's SDU. In order to process the request for payment forwarding, Texas must open a 40 case. Is that statement true or false? So select either A or B by clicking on the button next to the answer, and then click the Submit button. The poll is now open. You may notice a timer above the question with a 5-minute maximum for responses. This is a program default which cannot be changed. We're going to give you a maximum of 2 minutes for each question. But when we see that most of you have responded, we're going to go ahead and close the poll. So let's go ahead and submit the most appropriate answer that you believe and click the Submit button.
Jeanette and Diane, this is Liza. I've closed the poll, and now we're just waiting for the questions to clear.
Okay, thank you, Liza. Okay, the answers are up. 55% of you selected the correct answer. Next slide, which is false. The answer, as OCSD explained in AT 1707, a request for payment forwarding is not a request for the issuing state to open a 40 case. Instead, Texas should simply forward the payments it receives from the employer to New Mexico's SDU. And remember, FFP is available to effectuate payment forwarding.
We'll look now at one-state remedies with an emphasis on direct income withholding orders. Federal regulations define one-state remedies as the exercise of a state's jurisdiction over a non-resident parent or direct establishment, enforcement, or other action by a state against the non-resident parent in accordance with the long-arm provision of UIPSA or other state law. Federal regulations require states to determine whether it is appropriate to use one-state remedies, including direct income withholding, when the non-custodial parent resides in another state. A basic premise of both UIPSA and federal law is that a state may enforce a child support order across state lines by sending an income withholding order to an employer in another state without first filing a pleading or registering the order with a tribunal of the employer state. Employers must treat these direct out-of-state income withholding orders, if regular on their face, as if they had been issued by an in-state tribunal. Another basic tenet of UIPSA is that if a state is sending a direct income withholding order across state lines that is based on another state's order, the enforcing state cannot modify the other state's order. A state can modify another state's order only if it has modification jurisdiction under UIFSA. This means that the enforcing state using direct income withholding must abide by the terms and the payment location reflected on the controlling order, including the payment location of the other state's SDU. As noted in the comments to UIFSA Section 502, the destination of the payments must correspond to the destination originally designated or subsequently authorized by the issuing tribunal. This is a long-standing principle and part of OCSE's policy guidance since 2001. In AT 1707, OCSE confirms this long-standing rule. OCSE does recognize that some states have system concerns with designating another state's SDU on an income withholding order. AT 1707 provides that if a system cannot generate automatically an income withholding order that designates the appropriate SDU, the state may generate manually an income withholding order with the correct SDU and necessary case and payment information. However, any offline generation must be captured on the system as required by the certification guide for manual operations.
So now let's look at a scenario involving direct income withholding. Here, the custodial parent, Kathy, receives child support services in Minnesota. Minnesota issues a support order for Steve to pay support for their daughter, Sophie. Steve then moves to Florida and stops paying support. So what should the child support professional in Minnesota consider in determining the most appropriate action for this case? So federal regulations require Minnesota to first look at direct enforcement of its order. Minnesota should search for an employer for Steve. If there's an employer data match, the agency can send its income withholding order to that employer directly. Once the income withholding order is in place, payments will flow from Steve's employer in Florida to Minnesota's SDU to be dispersed to the family. This scenario is the simplest example of direct income withholding, where the order state continues to enforce its own order after the non-custodial parent moves to a different state.
Using the facts in Scenario 2, Minnesota decides to send its income withholding order to Steve's employer located in Florida. Is the following statement true or false? The Florida employer must withhold child support from Steve's paycheck and send those payments to Florida's SDU. Select either A or B by clicking on the button next to the answer, and then remember to click the Submit button.
I've closed the poll, and now we're waiting for the questions to clear. Thank you.
And the poll is closed. As you can see, the results. The correct answer to this question, the second part of the answer, is false, and the vast majority of you got that correct. Because Minnesota is the order-issuing state, the income withholding notice will designate Minnesota's SCU as the payment location, not Florida's. Please note that the first part of the answer is true, that as long as the income withholding order appears regular on its face, UEPSA requires the employer in Florida to honor Minnesota's withholding order. In the Interstate 201 training, we explained that regular on its face means that any reasonable person would think that the income withholding order is valid. This occurs when the order is payable to the state disbursement unit, the amount to withhold is a dollar amount, the text of the OMB approved form has not been changed, and the OMB form number is listed on the form, and the order contains all of the necessary information to process the income withholding order.
So let's try a scenario that's a bit more complicated. In scenario 3, a tribunal in North Dakota entered an order for Jack to pay child support for Jane for their son Luke. Jane and Luke moved to South Dakota, and Jane applies for TANF. Jack remains in North Dakota. What should the child support professional in South Dakota consider in deciding the most appropriate service for this case? The federal regulations provide that South Dakota has 20 calendar days to open a 40 case, establish a case record, and solicit necessary and relevant information from the custodial parent and other relevant sources. Federal regulations also state that South Dakota must make 3 determinations. 1, whether there's an order in another state. 2, whether the non-custodial parent lives in a different state. And 3, whether one-state remedies are appropriate. To decide whether a one-state remedy is appropriate, South Dakota needs to know the answers to the question on this slide. Is there an open 40 case in North Dakota? And is there a current income withholding order collecting support? So using the facts in scenario number 3, which of the following is not the best way for South Dakota to gather relevant information? A, talk to the custodial parent. B, use interstate communication tools. C, request information from North Dakota. Or D, tweet hashtag need information on Jack in North Dakota. Select the best answer and click on the button next to the answer. Remember, please, to then click the Submit button.
The results are clearing. Wait one moment, please.
Okay, almost all of you picked the right answer, which is D. Twitter is just not the best way for South Dakota to gather relevant information. But the rest of the answers are correct. South Dakota may obtain information by talking to the custodial parent, using interstate communication tools, and requesting information such as a copy of the order or payment records from North Dakota.
Using the same scenario, let's assume that South Dakota finds there is a current income withholding order that North Dakota issued, requiring Jack's employer to withhold support payments, and payments are being made. This case would then be just like scenario 1, where South Dakota may request payment forwarding from North Dakota on the Child Support Enforcement Transmittal Number 3, and payments will flow from Steve's employer to North Dakota's SDU, to South Dakota's SDU, and then to the family. But as we'll see in the next slide, there's another option depending on the facts of the case. Now, let's assume that there is no income withholding order currently collecting support. Again, under federal regulations, South Dakota needs to determine whether enforcement of North Dakota's order through direct income withholding is the most appropriate service. If the child support professional in South Dakota is able to find an employer for Jack, South Dakota may send a direct income withholding order. Here's another polling question. South Dakota is able to locate employer for Jack in North Dakota and decides that direct income withholding is the most appropriate service. When South Dakota sends a direct income withholding order, the withholding notice may have South Dakota's SDU as the payment location. Is that statement true or false? Again, you're going to click on the button next to the answer and then remember to click the Submit button.
Jeanette and Diane, I'm leaving this open for about 5 more seconds, and then I'll close it down.
Okay. Thank you. Well, it looks like this one was a bit trickier for most of you. The correct answer to this is false. Remember, under UIFSA, the enforcing state using direct income withholding on another state's order may not modify the other state's order, including the location for the payments. So South Dakota cannot change the payment location designation set forth in the North Dakota order. The payments are to be made to the North Dakota SDU. Instead, South Dakota's income withholding order should direct Jack's employer to send the payments to the North Dakota SDU. In order to receive those payments, South Dakota must also send the Child Support Enforcement Transmittal Number 3 to North Dakota requesting payment forwarding to South Dakota's SDU. After both of those steps are taken, Support payments will flow from Jack's employer to North Dakota's SDU to South Dakota's SDU and then be dispersed to Jane.
So there's some important things to remember if you're using direct income withholding on another state's order. First, the order state's SDU can only process incoming payments correctly if the income withholding order that went to the employer contains the correct identifying case and payment information. So it's really important that the enforcing state sending the withholding order obtain all the necessary information through either interstate communication tools such as SESNet or QUIC, or request copies of orders and payment records through EDE, or on the Child Support Enforcement Transmittal Number 3, Request for Assistance Discovery. Second, the enforcing state must include all necessary information on the withholding order that will allow the other state's SDU to process the payments. Third, the payment forwarding request must be on Child Support Enforcement Transmittal 3, Request for Assistance Discovery, and should be sent before the withholding order is transmitted to the employer in order to alert the order state of where it should send any incoming payments. Finally, if the state system cannot automatically generate an income withholding notice with the correct payment location, a manual workaround is allowed but must be captured on the system as required by the certification guide. So we're almost halfway through our training today, and before we move on to two-state case enforcement, we're going to take just a couple of questions from the phone lines and WebEx. Operator, if you can please open the phone lines.
Thank you. We will now begin the question and answer session. If you'd like to ask a question on the phone lines, press star then 1. Make sure to unmute your phone line and record your name. If you need to withdraw your question, press star then 2. Again, to ask a question, press star then 1. It may take a few moments for the questions to come through. Please stand by.
Thanks. And while we're waiting, we'll address the two questions that we have on the WebEx, which relate to scenario number 1. If you recall, scenario number 1, we had a Texas tribunal entering the support order, the non-custodial parent remaining in Texas, and the custodial parent and child moving to New Mexico, where they have applied for TANF. In the scenario, Texas 40 agency was not involved, but as in many cases, there could be an income withholding order that was either entered by the court or through the parties' counsel that was collecting child support through income withholding. This scenario is very similar to AT 17. It's related to 1707, question 3 and answer 3, which dealt with the child support agency in the issuing state never being involved. And the question comes down to, whether the state case registry is up to date with regard to records for every case in the state, and then it also relates to the payment forwarding question. So New Mexico is going to be the one with the open 40 case, and it's going to be the one that's requesting payment forwarding from Texas, and it's going to be the Texas SDU that's going to send the payments over to New Mexico's SDU, and then either to Anna and Ben or retain those for the state assistant. Operator, is there any questions through the phone line?
Yes, we do have 4 people queued up. The first one, Kelly Daves, your line is now open.
Hi, yes. This is in reference to the third scenario in which the wage withholding order was not in place already, and South Dakota decided to do a direct wage withholding. In the situations we've had, we've done the notice of intent to income withhold sent to the defendant by certified mail, and then had the payments directed back to our state directly. We've not been doing the payment pass through. So is that how we're supposed to start doing it now?
So thank you so much, Kelly, for that question. Because it was kind of complex, and I certainly wouldn't want to give you an incorrect answer, what I'm going to ask you to do is submit that question through the email address that you're going to see at the end of the training today, and OCSE will respond to that. So, but thank you for your question. Operator, I think we have time for one more.
Okay, our next question is from Wendy Amell. Hello, Wendy, your line is open.
I'm sorry, I was on mute. I apologize. Back in scenario number 1, and when I was registering to ask this question, you were in discussion on it. Again, could you reiterate, if it's a non-4D case in Texas, New Mexico is supposed to contact the clerk of the courts to see if there is an active wage withholding?
So that's a great question, Wendy. The payments, if there's an active income withholding where payments are flowing through Texas's SDU, Texas's SDU, as part of the federal regulations, is going to have to keep track of the payments, incoming payments, and the payments that are being dispersed. So that's where I would start. Jeanette, do you have a different answer, or does that sound right to you?
No, I think that sounds good. As long as payments are flowing, you can request payment forwarding. I don't think you really even have to find out if it's an income withholding order. If they're receiving payments, you can request the payment forwarding. I think we should acknowledge, too, that this is a fairly new concept for people, and we know that you have to really think about it, and you're going to have lots of questions related to payment forwarding because it's new for most of us.
Thanks, Jeanette. And I'm hoping that the training today shed some light. But again, we devoted a couple of pages in the AT on this, on payment forwarding. So please go ahead and use that really valuable resource. If you haven't looked at it yet, please read it after today's training. And we're going to take some questions at the end as well. Thank you so much for calling in and submitting those over WebEx. But we're going to go ahead and jump into part 2 to make sure we have time for all of the material. So we're going to move on to two-state enforcement. In AT 1707, OCSE refers to two-state enforcement as an interstate 4D case, which is the term used in regulations. So federal regulations define an interstate 4D case as, quote, a 4D case in which the non-custodial parent lives and or works in a different state than the custodial parent and children that has been referred by an initiating state to a responding state for services. An interstate 4D case also may include cases in which a state is seeking only to collect support arrearages, whether owed to the family or assigned to the state, end quote. So the basic premise in a two-state enforcement case is that the state providing services to the custodial parent or that has assigned arrears initiates an interstate 4D case to the responding state where the non-custodial parent resides or has income or assets. This cooperation between states to collect child support has been part of the 4D program from its inception. In 1984, Congress passed the Child Support Enforcement Amendments, which improved interstate enforcement in a number of ways, including allowing both initiating and responding state agencies to count the child support collected for computing incentive payments. This really provided the financial incentive for states to work two-state cases, and in 1988, OCSE issued final rules effectuating that new law. Two-state enforcement is also a major tenet of UIFSA. Therefore, both federal regulations and UIFSA detail the responsibilities of the initiating and responding state agencies. So in accordance with federal regulations, the responding state enforces the support obligation through its intrastate enforcement tools, including its regular income withholding procedure with its SDU as the payment location. Federal regulations also specify that the responding state must forward the payments received by its SDU to the initiating state within 2 business days.
So let's look at a scenario and how the two-state case works in practice. In this scenario, David receives child support services in Virginia, where the support order was entered, requiring Barbara to pay support for their 3 children. Barbara moves to Vermont and stops paying support. What should the child support professional in Virginia consider in determining the most appropriate service for this case? First, Virginia needs to consider using its one-state remedies and should look for an employer for Barbara in Vermont. If Virginia cannot locate an employer, or if the case needs additional enforcement action, Vermont would be better suited to enforce Virginia's order because it can access local services such as employment referrals or use in-state enforcement tools like driver's license suspension. Virginia may refer the Interstate 4D case to Vermont using the Child Support Enforcement Transmittal Number 1 initial request to request registration and enforcement of Virginia's order. Using the facts in Scenario 4, Virginia decides to send a 2-state case to Vermont, and Vermont locates an employer for Barbara. Is the following statement true or false? Vermont should send its income withholding notice to Barbara's employer, designating Vermont's state disbursement unit as the location for the employer to send the payments. Select either A or B by clicking on the button for true or false, and then click the Submit button. And it looks like the poll is closed, and we're just waiting for the results. And most of you have answered this one correctly. It's certainly a more familiar scenario to us. The answer is true. Once Vermont receives the interstate referral, it will decide whether to administratively enforce the Virginia order or register it for enforcement. Under either approach, Vermont will initiate income withholding by locating an employer for Barbara and sending the employer a Vermont income withholding order with Vermont's SDU designated as the payment location. Payments will then flow from Barbara's employer in Vermont to Vermont's SDU to Virginia's SDU and then on to David. While we've been talking primarily about income withholding so far, The payment flow here also applies to collections received from Vermont's use of other enforcement tools, such as voluntary payment to the SDU to qualify for reinstatement of a suspended driver's license. In addition, this payment flow applies regardless of whether Vermont administratively enforces the order or registers Virginia's order with a tribunal for enforcement.
So let's try another scenario. Here, a tribunal in Georgia entered an order for Zach to pay child support to Amy for their daughter Lisa. Amy moves with Lisa to Arizona and applies for child support services there. Zach now lives in Colorado. You see that this scenario involves 3 states. So what should the child support professional in Arizona consider in deciding what services are most appropriate for this family? Since multiple states are involved here, Arizona first needs to learn the involvement and status of the case in other states, whether there are open 40 cases in either Georgia or Colorado or both, and whether there's a current income withholding order collecting support. If there is, Arizona needs to determine the current payment flow for those support payments. Arizona also needs to obtain Georgia's order, case information, and payment records from Georgia through available interstate communication tools like SESNet, QUIC, and FCR Query. Arizona may send a request for documents to Georgia either by EDE or on Child Support Enforcement Tribunal Number 3, Request for Assistance Discovery. So let's take another poll. Using the facts in scenario 5, is the following statement true or is it false? If Arizona learns that Georgia has an income withholding order that is currently collecting support from Zach's employer in Colorado, Arizona should also send a direct income withholding order to Zach's employer, listing Arizona's SDU as the location for the employer to send payments. Select either A or B and click on the button next to that answer. Remember to then click the Submit button. Okay, the poll is now closed. We're going to wait for the results. Okay, and almost all of you got the answer correct. The statement is false, and that's for several reasons. First, if Georgia has an income withholding order collecting support, Arizona should consider requesting payment forwarding from Georgia. Second, Arizona should not send its own income withholding order when Georgia already has an income withholding order collecting support. It could subject the parent to double enforcement and probably would be confusing for the employer. Finally, when using direct income withholding on another state's order, Arizona may not designate its own SDU as the location to send payments.
Let's take another poll using those same facts. Is the following statement true or false? If Georgia does not have an open case, the most appropriate action would be for Arizona to send a two-state case to Georgia. Select either A or B, and again, click the Submit button. It looks like Liza has closed the poll, and we'll wait for those results. And it looks like most of you answered this in the way we would. This one's a little tricky, but under the facts presented, the statement is most likely false. There's no indication that the non-custodial parent has any assets in Georgia from which to collect child support. Further, Georgia does not have an open 4D case and is not currently involved in enforcing its order. Instead, the most effective enforcement under these facts would likely be to refer a two-state case to Colorado, where the non-custodial parent resides. Colorado would be able to use all of its intrastate enforcement tools to collect current support and, if applicable, of course, past due support from the non-custodial parent. If Arizona sends a two-state case to Colorado, however, Arizona should consider how Georgia, as the order-issuing state, will be affected.
So let's talk for a minute about payment records. Federal law and regulations require child support agencies to maintain a payment record for all 40 cases. This payment record must include the amount of current support, collections and distributions, and the amount of any arrearage, including interest, late payment penalties, and or fees. For non-40 orders, child support agencies are neither required to maintain a 40 payment record, nor is FFP available to do so. However, every state's SDU must maintain information on the amount of support collected and dispersed through the SDU for every case, regardless of whether it is 40 or non-40. Finally, under UIFSA, the tribunal that issued the support order has the ultimate authority and duty to determine whether the non-custodial parent has fully complied with the payment of current support and arrears. And turning back to our discussion of two-state enforcement, there are cases where neither the initiating nor the responding state is the order state. If so, it's the duty of the initiating state to inform the order state that it's referring a two-state case to the state where the non-custodial parent resides. This is important because if the order state has an open 40 case, it will be able to coordinate enforcement with the initiating state, and both states can exchange payment records to ensure accurate balances. Even if the order state does not have an open 40 case, the tribunal that issued the order may need payment records from the initiating state if the tribunal must make a determination of arrearages under its order. The order state will have the option to designate the frequency of payment record updates and how it would like to receive those payment records, such as by EDE. So let's go back to scenario 5. Arizona must notify Georgia when it refers the two-state case to Colorado. Even though Georgia does not have an open 40 case in this scenario, the tribunal in Georgia that issued the order has the ultimate responsibility under UIFSA to determine arrears owed under that order. If and when there's a dispute on arrears, the tribunal and the Georgia 40 agency will know to contact Colorado and Arizona for payment records.
So let's move on now to intrastate enforcement of another state's order. Sometimes both parents leave the order state and wind up in the same state. When that occurs and the custodial parent applies for services in the new state, UIFSA allows the child support agency to enforce the order using its intrastate processes. If the non-custodial parent does not contest administrative enforcement of the order, UIFSA permits the agency to send its income withholding order to the parent's employer. As we learned in the Interstate 201 training, if the parent does contest administrative enforcement, then UIFSA allows the agency to register the order, making it enforceable in the same manner and subject to the same procedures as an order issued by a tribunal in that state. Now let's move on to another scenario. Here, a Wisconsin tribunal entered a support order. Mike applies for child support services when he moves to Illinois with his 2 children. Sue, the non-custodial parent, also resides in Illinois. What options are available to Illinois in this case? Illinois may either use administrative enforcement or register Wisconsin's order for enforcement. One additional note from the AT 1707 about the impact of modifying the order in these intrastate scenarios. If either parent asks Illinois to review the case for modification, and it is appropriate given the facts of the case, Illinois may register the order for modification. Under UIFSA, an Illinois tribunal may then modify Wisconsin's order and assume continuing exclusive jurisdiction because both parents reside in Illinois. Once that occurs, the payment flow remains the same, but Illinois, rather than Wisconsin, will be the state responsible for the payment record and the balances owed in the case prospectively from the date of modification going forward. And here we have another poll. Using the facts in Scenario 6, Illinois opens a 4D case for Mike and identifies an employer in Illinois for Sue. Is the following statement true or false? Illinois may send its income withholding notice to Sue's employer, designating the Illinois SDU as the location for the employer to send the payment. Again, select A or B and then click on the Submit button. And the poll is closed. We'll wait just a second for the results. And most of you answered this as we would. The statement is true. Whether Illinois decides to use administrative enforcement or register Wisconsin's order with a tribunal, Illinois may use its income withholding order to collect support from an employer in Illinois. Like in a support payments will flow from the employer to Illinois' SCU to the family. As in a two-state case, Illinois must notify Wisconsin that it is enforcing the Wisconsin order.
So our final case processing option arises from Section 319 of UFSA. OCSC refers to this option as UFSA Section 319 redirection, which the AT defines as follows. As authorized by Sections 307 and 319 of UFSA, redirection is the change to the payment location set forth in the child support order by the order issuing state. It corresponds to the new intergovernmental form called Child Support Agency Request for Change of Support Payment Location pursuant to UFSA Section 319. UFSA Section 319 redirection was added to UFSA in 2001 and maintained when UFSA was amended in 2008. Now that all states have enacted UFSA 2008, UFSA Section 319 redirection is an option for all states, but only in cases where both parents have left the order state and the custodial parent is receiving 4D services in a new state. So how does UFSA Section 319 redirection work? At the start of the process, the order state receives a request on the new intergovernmental form, Child Support Agency Request for Change of Support Payment Location pursuant to UFSA Section 319 form, which we will refer to as the UFSA Section 319 request form. Once it receives the form, the order state confirms that neither of the parents reside there and the custodial parent is receiving services in a new state. Next, the order state must do two things. First, it must redirect payments administratively or judicially to the requesting state's SDU. Second, it must notify the non-custodial parent's employer of the new payment location by sending a new income withholding order or an administrative change of payee. One of the things that most concern states regarding UFSA Section 319 redirection is that the payments no longer will flow through the order state after redirection, which it can create a number of problems if the order state has an open 40 case. Those problems include not being able to close the case under one of the criteria listed in the federal regulations, and therefore continuing to have the obligation to enforce the order without knowing whether payments are being made to the new SDU. Another problem is that the order state no longer is able to count payments collected for incentives because payments are redirected away from its SDU. The final problem that was raised is the ability of the order state to collect assigned arrears following redirection. The State 40 directors met with OCSC to discuss these concerns and asked OCSC to include, as a best practice in its AT, that states should request UFSA Section 319 redirection only where the order state does not have an open 40 case, which addressed all the problems. OCSC agreed and included that guidance in the AT, stating, quote, as a best practice, UFSA Section 319 redirection is an appropriate option where the individual parties no longer reside in the order issuing state, a new state's providing child support enforcement services, and the order issuing state does not have an open 40 case. If the order issuing state has an open 40 case, the traditional federally authorized interstate options described in this AT are available for states to use instead of UFSA redirection and must be considered in assessing the appropriate services to provide in each individual case, end quote.
We have one final scenario with 3 polling questions to illustrate the UFSA Section 319 redirection. In our last scenario, a tribunal in Oregon entered an order for support. Kate, the custodial parent, moves to California with her son, Brett, and applies for child support services. The non-custodial parent, Jim, now resides in Washington. What should the child support professional in California consider in deciding whether a UFSA Section 319 redirection is appropriate for this case? California needs to consider a lot of facts before deciding UFSA Section 319 redirection is the most appropriate service for this family. California should determine whether either Oregon or Washington, or maybe both, have open 40 cases, and whether there's any income withholding order currently collecting support. It can use its interstate communication tools to find the answers to those questions, as well as the Child Support Enforcement Transmittal Number 3.
So using the facts in scenario 7, is the following statement true or false? California must request UFSA Section 319 redirection if there are no open 40 cases in Oregon or Washington, because no one resides in the order issuing state of Oregon, and California is providing child support services. Select the best answer and click on the button next to the answer. Remember to then click the Submit button. Okay, I see that the poll has closed. Please hold for those responses. Okay, the polling results are up on the screen, and unfortunately, the majority of you did get this one incorrect. The right answer was false. Requesting USISA Section 319 redirection is always discretionary, never mandatory. California is permitted to request USISA Section 319 redirection under the facts in this scenario because no one resides in the order issuing state, the custodial parent's receiving child support services in California, and no other state has an open 4D case. But California has other options to consider. Before requesting USISA Section 319 redirection, California must consider several things, including whether referring a two-state case to Washington is the most appropriate action, because that's where the non-custodial parent resides, whether there's a paying income withholding order, and whether requesting payment forwarding from Oregon is the most appropriate action. And if California identifies an employer, whether direct income withholding and payment forwarding from the order issuing state's SCU is the most appropriate action.
Using the facts in Scenario 7, is the following statement true or false? If California requests a UIPSA Section 319 redirection, Oregon can refuse to redirect payments because redirection is discretionary. Again, you're going to select A or B and click on the Submit button. And the poll is closed. We'll wait a moment for the results. And the majority of you did get this one correct. The statement is false. While the 4D agency providing services to the custodial parent always has discretion in requesting UIPSA Section 319 redirection, once the request is made, the order issuing state must comply with the request. Here, neither parent resides in Oregon, the issuing state, and the custodial parent has applied for services in California. Because there are no open 4D cases in Oregon or Washington, California may request a Section 319 redirection, and Oregon must comply.
So here is our last polling question. Using the facts in Scenario 7, California sends a request for UFSA Section 319 redirection to Oregon, and all of the elements of UFSA Section 319 redirection have been met, which of the following is not a service that Oregon must provide? A, Oregon must redirect payments to California's SDU. B, Oregon must determine if UFSA Section 319 redirection is the most appropriate service. Or C, Oregon must send Jim's employer a new income withholding order or administrative change of payee. Select the best answer and click on the button next to the answer. Remember to then click the Submit button. Okay, the poll has closed. Let's wait for the results. Okay, the majority of you picked B, and that is the correct answer. As long as the requirements for UFSA Section 319 redirection have been met, Oregon may not consider whether redirection is the most appropriate service. The determination of whether redirection is the most appropriate service is up to California. Answers A and C are services that Oregon must provide once it receives the UFSA Section 319 request form. Oregon must redirect payments to California's SDU, and it has the option of doing that administratively or judicially, depending on I apologize. It must administer judicially depending on Oregon's law. Oregon also must notify the non-custodial parent's employer of the new payment location, and it has the option of either sending a new income withholding order or an administrative change of payee to the employer. Once these steps are taken, payments will flow from Jim's employer in Washington to California's SDU to the family. As you can see, the family may receive child support payments faster after redirection because the payments no longer flow through Oregon's SDU. So let's review some of the important concepts that were covered in the Interstate Payment Processing training. First, states must consider all options in interstate cases to determine the most appropriate services to provide in an individual case. Second, states must cooperate with each other in enforcing support obligations across state lines. Third, the order state should be notified whenever another state is enforcing its order. Finally, interstate communication is critical in serving families in interstate cases. So unfortunately today we are almost out of time, and we want to do a quick wrap up. If you have submitted a question through WebEx that wasn't answered today that you would like answered, please email that question to OCSE. It'll provide them with the ability to get back to you if there's some clarifying questions. Also, if you did not submit a question through WebEx, but we're going to call in, again, use this email address to submit your questions, the email address listed on the slide. We have a couple of hyperlinks to walk you through. Here, OCSE has provided hyperlinks to both UFSA 2008 and the AT 1707.
And this does conclude our interstate payment processing training. We do have 2 more interstate training sessions for you in January and February of next year. Registration for these events will be available in a couple of weeks prior to the dates listed on the slide, and we hope you'll join us for these trainings as well. Finally, OCSE will post the recordings and the PowerPoints, including the trainer notes, from all these sessions on the OCSE website for your future use and for you to share with colleagues who may have been unable to attend any of the sessions. OCSE thanks you for your participation today and looks forward to having you at our 2 remaining trainings early next year.
That concludes today's conference. Thank you for participating. You may disconnect at this time. Speakers, allow a moment of silence and stand.